Well, winter's here, and that means a lot of things. Obviously, that means it's going to get cold. In a lot of places, it's already very cold. It also means it's going to get dark a lot sooner. If you live in the Northeast like me, that means 4:30 at night, it's going to be dark. But for a lot of people, in fact, millions of people across the United States, it also means skiing season. And those people hit nearly 500 resorts across 39 states every year. Now, a lot of times, skiing means a lot of fun. It means adrenaline rushes. It means good times with friends and family. For some people, it could be even relaxing. But for other people, it could also mean injuries. Now, although the statistics for the amount of injuries is not entirely known, there are various studies that show around 40 deaths and up to 40 serious injuries, such as paralysis and serious head trauma, occur in any given year because of skiing. Now, obviously, where there's skiing, there's inherent risks associated with skiing. Now, before you hit the slopes, and whether you're an expert, a novice, a beginner, whatever the case may be with skiing, there's some issues that need to be hashed out, especially by the resort, so as to avoid their liability if you fall and hurt yourself either seriously or in some other way. Now, you may end up walking up to a ticket booth, and you'll see a big sign on top of you with a big red warning on top of it that talks about liability of certain causes of action against the ski resort. You'll also, a lot of times, see on the back of your ticket the exclusion of liability. And on the back of the ticket, it'll say exactly what you cannot hold the ski resort liable for. Now, there are a lot of misconceptions about contracts as a whole. And a lot of people think that, oh, if I and the ski resort are not signing some sort of written agreement, there's no contract. That's not the case. If you have signs and you have a ticket that expressly excludes the resort from liability, it can, so long as it does not contradict public policy within the state that you are in, it can be held enforceable, and it will be held against you if you, quote unquote, entered into that contract by being aware of it, or you should have been aware of it, and you nevertheless took upon going into that activity on your own. Now, before I even get into my discussion on waivers of liability, there are some principles of tort liability that I just want to hash out to make sure that you understand it first. There's something called a business invitee. If a business is running, obviously, a private business, and I enter onto that business to conduct business of my own, or I'm a customer, so on and so forth, under the business invitee rule, the business has to provide me with reasonable and ordinary care to keep the premises safe. So, for instance, a court in Missouri held that the defendant would be liable, the business would be liable, if it knew or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk of harm to invitees. B, should expect that invitees will not discover or realize the danger or will fail to protect themselves against it. And C, fails to exercise reasonable care to protect the invitees against the danger. So, essentially, the business has to protect me from these sorts of activities that are not readily apparent and that I can't, through ordinary care, become aware of. So, obviously, with skiing, there's some inherent risk associated with it. But obviously the question becomes, well, what if the ski resort is doing construction on a certain part and maybe there's different structures around that I could crash into? Or what if a portion of the ski mountain ended up falling down almost kind of like a pothole, and this was not something that was contemplated within the scope of the liability and or the assumption of risk. So this is essentially what the ski resorts are trying to protect themselves against. They don't want these unknown risks that are possible when I am skiing to be held against them. So there's something in tort law called assumption of risk. Essentially, the idea of assumption of risk is if I assume the risk of something, I can't hold the other party responsible for that risk. And there's two types of assumptions of risk. There's express assumptions of risk, and there's implied assumptions of risk. Obviously, an implied assumption of risk is something that's just obvious. For instance, if I decided to play tackle football with my friends and we were all tackling each other and thereafter I got upset because I was tackled, I can't sue one of my friends for tackling me under an assault and battery theory of torts. That wouldn't make sense because I assume the risk knowing that being hit and tackled was an inherent risk of playing tackle football. But there's also something called an express assumption of risk. And with an express assumption of risk, this is something that the business and or other party alerts me to that says that this is a possibility of risk that you are taking on by participating in this activity. And therefore, if you participate in this activity, you understand that this is a risk and you cannot hold me, the company, business, and or other party liable if you are harmed by that risk. So the general idea when we're talking about express assumptions of risk is that it has to conspicuously and unmistakably notify me of the risk that I am undertaking. Now, different courts across the country hold different standards when they're talking about express waivers and essentially express assumptions of risk. Because when I am signing a waiver, essentially what's going on is it's an express assumption of risk. I am being notified that this is an assumption of risk, and I am waiving that assumption of risk. And the standard differs across the country. Therefore, it's not possible for me to sit here within a couple of minutes and go through the law of every various state. And your job is to know the law of the state for which you are skiing. But there are some general principles that are consistent across the states. And the first one being that the waiver of the assumption of risk has to be conspicuous and it has to be clear. Okay? So when you look at some of these waivers, and this is just an example of a waiver, and you see this, and you're looking at it, and you're like, oh my God, and you're someone who maybe doesn't know anything about the law, you have all of this legal jargon, and you're just looking, and you just want to ski, and you see all, this huge agreement that, just pages long, pages, and you don't know a word that's on there, but you just sign it at the bottom, right? And you sign it, and what's going to happen is you can't thereafter say, well, I didn't read what I was signing. That's not enough for the court. You can't thereafter say that I didn't understand what I was signing. If you are a capable adult with a sound mind, you are required to undertake your own research and investigation to understand what type of contract you're entering into. What it's really going to come down to is whether or not this is against public policy. And as I indicated before, many states hold different standards when it comes to public policy. For instance, in Washington, when determining whether this is a violation of public policy, the enforceability of a release depends upon whether, 1, the agreement concerns the endeavor of a type thought suitable for public regulation, 2, the party seeking to enforce the release is engaged in performing an important public service, often one of practical necessity, 3, the party provides the service to any member of the public or to any member falling within established standards, 4, the party seeking to invoke the release has control over the person or property seeking the service, 5, there is a decisive inequality of bargaining power between the parties, and 6, the release is a standardized adhesion contract. Similarly, in other states, they hold the same thing. Now, in New York, the court has held, and this seems to be a common standard across the country, that the enforceability of one of the releases of liabilities depends upon whether or not the language of the release encompasses the actual risk that caused the plaintiff's injury and thus the bar on total disclaimers. Okay? So essentially, when you're signing one of these things, it has to be conspicuous. When we're looking at this, if there's a bunch of fine print, a court may not find this conspicuous. But if you look, there's bold letters in this agreement. There's capital letters. We see bold in the third paragraph and capital. Undersigned understands and agrees that the agreement will apply for every day participant engages in any activity during the term of this agreement, without requiring undersigned to sign an additional agreement for each day and or each activity until undersigned revokes it in writing and in the writing is accepted in writing signed by the resorts. And the next paragraph, it says, in addition, adult acknowledges, understands, and agrees that by signing this agreement, adult for him, herself, and if applicable on behalf of minor, is voluntarily assuming, underlined capital bold, all dangers and risks of skiing, inherent or otherwise, and is waiving rights and releasing claims in connection with dangers and risks above and beyond those addressed by the act. Now, obviously, some states have acts that regulate skiing, so that's what they're referring to. And then in the next paragraph, just to make it clear, it goes on to talk about different sorts of risks that are possible in skiing. Physical injury, death, high elevation wildlife encounters, falling trees, limbs, marked and unmarked obstacles, deep snow conditions, tree wells, slick or uneven walking surfaces, surfaces covered with ice and snow. And the reason why they do this is because when I am entering into a release, the terms have to be clear. And it has to be the intent of the parties to release the liability on that waiver. Because if it's not, then the court is not going to uphold it. So the language that's in one of these agreements is very, very important. For instance, a court in Oregon, in the case of Steele v. Mount Hood Meadows, Oregon Limited, held that the release on a ski ticket stating that the skier, quote-unquote, assumes the inherent risks of skiing did not clearly and unambiguously release the operator from liability for the operator's negligence. So that was a case where the language was so broad that the court held that it wasn't unambiguous, it wasn't conspicuous, and it wasn't the intent of the parties to release that specific injury from the liability of the operators of the ski resort. So it's very important that it's within the scope of the release that I'm entering into. So, general principles to end this. As I indicated before, the law differs across the country whether or not these sorts of releases are going to be upheld and whether or not they are against public policy as dictated by the states in which I or you or somebody else chooses to ski in. Now, some states have specific statutory laws that set out exactly what the ski resort can waive liability to, and that's obviously set out by the legislature. And other courts, it's just by means of case law. Nonetheless, the general principles that are prevalent in every state is that the language in the release has to be conspicuous, it has to be unambiguous, and it has to be the intent of the parties, meaning we have to be aware that we are waiving liability for this before we go on and participate in this act. So when we see these sorts of releases, and this is an example of another release, we see, again, in all capitals, right? I hereby assume full responsibility and risk of bodily injury, death, or property damage as a result of my participation in these sports and or my use of the rented equipment, regardless of whether the injury, death, or property damage is caused for in whole or in part by the negligence of Charles River Recreation Incorporated, the Commonwealth of Massachusetts, Massachusetts Department of Conservation and Recreation, and all the owners, officers, directors, agents, and employees. So, and this language jumps out at me. So they're going to look at this language and say, okay, is this conspicuous? Yes. Is it unambiguous, though? Is this the type of injury that falls within the scope of this agreement? Does this language encompass it? And that's really going to differ between state and state and what that particular state's policy is. So what's your job before you go skiing? Make sure that you understand the specific law of the state that you are going to go skiing in. Make sure that you read the waiver before signing it, and make sure you understand the dangers inherent in undertaking the activity of skiing.